Hi there. My name is Scott Shoemaker, and I am an estate planning attorney in Cedar Rapids, Iowa. And I wanted to thank you for downloading my complimentary 6-point checklist. It is on its way to your inbox as we speak. And while we wait for it to arrive, I wanted to just take a moment to introduce myself and give you a little bit of insight as to how I became an estate planning attorney. The practice of law is actually a second career for me. I spent about a decade working as a classical musician, and after I got married and had children of my own, I realized that I needed to find a career path that was a little bit more stable than the work I was doing as a musician. And so with the support of my wife, we sat down and did a lot of critical thinking and ultimately decided that I would go to law school, which I did. And since I wasn't your typical 20-something-year-old law student, I was actually in my early 30s by that point. I wasn't really interested necessarily in following the big law firm career path. And so I focused very intently on a solo and small firm practice. I interned at a small law firm for the last year and a half of my law school experience, and I ultimately ended up earning a certificate in solo practice from the law school. And after I graduated and passed the bar, I hung out my shingle, so to speak, as a solo practitioner. I ended up focusing a lot in those early years on criminal defense and family law. There's a lot of business to be had, and so that they sort of naturally developed into my primary areas. And as you can imagine, I found myself in the midst of a lot of very intense conflict over those couple of years that I focused in that area. And some people, they really thrive in a high conflict environment. Unfortunately, I'm not one of those people, and I learned that pretty quickly on. And I always like to share this story that sort of the straw that broke the proverbial camel's back. My wife and I were at a wedding in Grand Rapids, Michigan, with a graduate school colleague of mine, and we had gone to the wedding and the reception. We were back in our hotel room, and we had gone to bed, actually, and my phone rang. It was a client who had gotten picked up for a DUI, and so I took the call, and my wife sat very patiently on the side of the bed as I had not exactly the most coherent conversation with my client, as I explained that I was several hundred miles away, and that he was going to have to wait until the judge came in the morning before we were going to be able to do anything. And after a rather lengthy conversation, I hung up the phone, and my wife said to me, she said, "If that ever happens again," and then just sort of stopped. And mercifully never got around to finishing that sentence. But this illustrated that I was going in the wrong direction, and the conflict that I found myself embroiled in as a result of my work was having an impact on my family's life as well as my own, and I decided that I needed to go in a different direction. So I wrapped up that practice. I took a position at a large academic publisher as a contract person, primarily negotiating contracts with state departments of education, and starting kind of on the low end at about 10 million. The biggest contract I worked on was about $350 million. Many moving parts, multi-year contracts, lots of subcontractors, and that kind of thing. And it was very interesting for me when I took this position, because I'd always thought of the law as a tool that you turned to when things broke down, and you went to the lawyers in order to fix problems. And this company had a very anti-litigation stance, and they brought lawyers in very early in the process to negotiate the contracts and set up agreements with the goal of avoiding conflict before it could start, and by drawing very clear boundaries. And really, this process of managing conflict, avoiding conflict from the very beginning, was really kind of an epiphany for me. Really kind of opened my eyes to some really dramatic possibilities. I worked for the company for about a year and a half, and then unfortunately they outsourced all of their contracts workers, and I was laid off from my position there. I very distinctly remember being called into my boss's office on a Tuesday morning and being informed that that was my last day. Being the new guy, the most recent in was meant that I was the first person out the door, and they generously gave me a month's severance, and I was able to get some unemployment, and I went home and I thought really hard about how I wanted to continue my law practice, if I wanted to continue practicing law at all. And ultimately I decided, after interviewing for several other large companies and other litigation firms, that I really wanted to go back into solo practice and focus really on working one-on-one with individual clients. But I decided I was going to be very intentional about it, and I was going to do things in a different way. The first thing I decided is I was going to help families stay out of conflict, and so that's what ultimately led me to an estate planning practice, is that I was all about keeping families out of court and out of conflict. The second thing I decided is that I was going to be very intentional about the families that I worked with, and that I would vet my clients very carefully, because early on I pretty much took whatever clients came in the door, and sometimes my clients were interested in listening to my advice and sometimes not, and ultimately that led to some conflict with clients as well, and not the best experience on either side of the table. And then finally I decided I was going to get rid of the traditional hourly billing model, because that's a ridiculous way, an outmoded way, an ancient way of billing clients. It's not fair to clients, and we can do better than that. So that's how I got to where I am, working primarily in estate planning and probate. Today I want to take just a few minutes and talk with you about the two most important things in most of our lives. That is our families and our assets, and what would happen to each of them in the event that something happens to us. And I'm going to start with maybe the most difficult question that I have the opportunity to ask people on a regular basis. And that question is, and maybe you've given this some thought, but a lot of people haven't: what would happen from a practical standpoint? What would happen to your children, if you have them, if something were to happen to you? Take a minute and just take a moment and just think about that. You know, if your kids were at daycare, or if they were with a babysitter and you didn't come home. Well, let me explain what would happen. Normally, what would happen is law enforcement would get involved. You would have police officers come to your house, and if they were with a babysitter, or they would show up to daycare. And if you had been in an accident, or if your daycare provider or police or your babysitter were to call them because you had just vanished and they couldn't get a hold of you, and upon finding you there, they would almost certainly call the Department of Human Services. Police generally can't take children into custody on their own, and so they would call DHS, and DHS would begin the foster care proceedings. In the lack of any guidance, they would try to find someone to place the children with for the short term. And then over the long term, the decision about who would raise your kids would ultimately be left for a judge to decide. Now, if you have a lot of family nearby, this can really be problematic, because sometimes more than one family member is going to want to have custody of those kids, and a judge who doesn't know you or what's important to you, is going to have to decide how to raise your kids. Now, in my case, I have two different family members that would petition the court to raise my children, my sister and my sister-in-law. And on paper, my sister-in-law looks great. Experienced mom, good finances, secure relationship. My sister, not so good. She's in her 20s, no kids, no responsibilities. So if you were the judge, of course, who would you name? Well, of course you choose my sister-in-law. What the judge doesn't know, wouldn't know, couldn't know, is that my sister-in-law is the last person in the world that I would choose to raise my kids. And it's not that I don't love my sister-in-law, but the fact of the matter is my sister-in-law and I see differently on virtually everything that is important to me, politically, philosophically, religiously, educationally. And that's just simply not an environment that I would want my children to be raised in. So if you haven't taken steps to ensure that your kids are raised by the people that you want, if something were to happen to you, now is an opportunity to get a kids protection plan in place. And in a few minutes, I'm going to tell you exactly what that is and what you can do to create one for your children. You also need to think about who you would not want to raise your children. There's a well-known case out of Pennsylvania where, mom died and dad stopped letting grandma see the kids. Grandma sued, and after many years, the court agreed to give grandma some visitation rights. And dad says that mom and he had agreed that if something happened to mom, grandma was to have nothing to do with the kids. But unfortunately, that was never put into writing. And so who knows if that statement was actually true. If you haven't addressed these issues yourself, clearly and in writing, then you definitely need a kids protection plan. Now, our office has created a kids protection plan that addresses all of these issues and provides you with provides instructions to your caregivers. It allows you to name temporary and permanent guardians for your children, provides letters to everyone letting them know what to do, and allows you to confidentially exclude certain people from becoming guardians. And he even gives you an ID card if you would like, so that if you're in an accident, the authorities will know that you have minor children at home and know who to call immediately and who has legal authority to stay with your children. If you don't own a home, life insurance, or significant assets, significant assets in the bank, this may be all you need in order to ensure that your kids are cared for by the people you want in the way that you want, if anything were to happen to you. But you also need to think about how the people who will care for your children will take care of them financially. You see, it's your responsibility to ensure that you're leaving behind enough money to care for your kids the way that you want to be cared for, and to ensure that the people that are caring for your kids or for your money don't have to go to court to get access to those assets. If you own any real property or other assets over $100,000, or have your kids named as beneficiaries on your life insurance, then you have to think about what will happen to the assets you're leaving behind, because you're almost guaranteed a lengthy, messy, expensive court process that you can almost completely avoid, and we'll talk about that in just a moment. But before I do, I want to mention to those of you who have chosen guardians, in my experience, most parents who have worked with a lawyer to choose guardians or done it on their own have made one or more of 6 common mistakes. And what are those mistakes? Well, they've named a couple to act as a guardian rather than an individual. They've only named one guardian. They haven't considered the financial resources for the guardians to raise the children. If they only have a will, which means the court will distribute the money, it's totally public and it doesn't protect your money from divorce and other lawsuits. It doesn't exclude anyone who might challenge your decisions or address the people that you would never want to act as guardians for your children. And it has only named guardians, you've only named guardians for the long term and have neglected the short term. You haven't addressed the question of what will happen in those immediate minutes and hours until your permanent guardians can arrive. Now, why is it that people make these mistakes? The answer is simple. The fact is that most lawyers are not trained to plan from a parent's perspective. Most lawyers are not parents themselves, and they don't think of things like that. And, and as a result, there are gaps in most of the plans that you see prepared by most lawyers. Now that we've talked about your children, I want to talk a little bit about your assets. As I mentioned, it's your responsibility to make sure that you leave enough assets behind to ensure that the guardians of your children are able to raise your kids as you would want them to be raised without making them a financial burden. Now, you can leave those assets as savings, equity in a home, retirement accounts, or life insurance. If you have a business that could be sold upon your death, you need to make sure there's enough liquidity for someone to come in and run the business long enough for it to be sold so that the value of the business assets can get to your spouse and or to your children. Once you've considered what and how much you'll need to leave behind to your loved ones, the next one you'll need to consider is what will happen to those assets and how they'll get to the people you love. Think very carefully about everything you own. If you have assets over $100,000 and you haven't done much planning, or you have merely a will in place, you're, again, pretty much guaranteeing your family a long, drawn-out, expensive public court process called probate if something were to happen to both you and your spouse. So let's talk about that. What is probate? Probate is a legal proceeding that moves your assets from you to your heirs. In Iowa, you can expect a probate to last 18 months on average. 12 months is a general rule of thumb as a minimum, and up to 3 years. Probate is an expensive proposition. You can expect under Iowa law that 5% of your gross assets, that's calculated as a portion of the fair market value of your assets, not what is left after your debt is paid off, will go to the administrative costs of your probate. So let me give you just an idea of what that would look like. Let's say if all you have is a house that would sell for $500,000, just to make the math easy, the probate costs on that asset alone would be $25,000. The average probate estate in Iowa is $411,000, which means the average probate cost is over $20,000 in the state of Iowa. And if your children are under the age of 18, your assets would be placed in a guardianship estate or a conservatorship estate for your children, and the court would almost certainly appoint a financial guardian or conservator for those assets that would be distributed to your children over their lifetimes, and the remainder would be distributed to your children outright at the age of 18. This is totally open to the public and subject to financial creditors. The worst part about all of this is that this process is voluntary. Even if you have a will, only the people whose families, the only people whose families have to deal with the probate process are people that didn't plan. So if you own a house or you have assets worth more than $100,000, a will is not enough. A will not adequately protect you. Now, life insurance is not typically included in your gross estate for probate purposes, and because you designate beneficiaries when you buy life insurance. However, many people make the common mistake of designating their children under the age of 18 as beneficiaries on their life insurance, and if that's the case, those life insurance proceeds will go through probate because your children under the age of 18 are unable to own assets of that value in their own name. So if you named your kids as beneficiaries on your life insurance policy, we're back to square one. Now, I want to talk real briefly about estate tax. I will keep my comments regarding estate tax fairly brief because it doesn't apply to most people. As a matter of fact, the IRS only expects something in the neighborhood of about 15,000 estate tax returns to be filed in the United States this year because the current exemption is $11.5 million. And so if you own $11.5 million or less than $11.5 million in assets at the time of your death, then your estate will not be subject to estate tax. However, for estate tax purposes, life insurance is included, as well as anything that you inherit outright. If you're subject to estate tax, it's a hefty tax. It's about 40% of any assets you own in excess of $11 million. And if you, if you have a significant number of assets or significant amount of assets, you'll certainly want to plan in such a way to lessen that burden. Now, like probate, estate taxes are really voluntary, and the only people that pay them are people, again, that don't plan. Now, while the estate tax exemption is currently $11 million, meaning you won't pay, or $11.5 million, meaning you won't pay estate tax unless your estate is over that amount at the time of your death, there's two important things I want you to know about that statistic. The estate tax exemption is constantly changing. The estate tax exemption has been as low as $675,000, and it could be there again in the future. And the second point is anything that you inherit and all of your life insurance is included in your estate for the purposes of calculating estate tax liability. So while it may not apply to most of you, if it does apply to you, make sure that you speak with someone about avoiding estate tax, since it is voluntary and unnecessary. So I've given you a lot of general information, and I'm sure at this point that you are wondering what your specific next steps should be to ensure the well-being and care of your family in the event that anything happens to you. Well, the best way to take the next step and ensure that you leave things fully handled for the people you love is to ensure that you do not, and to ensure that you do not leave behind a big mess for your family to resolve, is to meet with me privately for a family wealth planning session. People who have experienced these sessions with me routinely say that they feel more financially organized than they have ever before, and that they have the total peace of mind and clarity about next steps. So here's how that works. Before the family wealth planning session, you complete a family wealth inventory and assessment. It's a detailed questionnaire about your current family situation, your goals, your concerns, and your assets. Then you meet with me for the planning session, during which we go through step by step what would happen to you if something were to happen to you, looking at everyone you love and everything you own. I will educate you specifically about your unique situation. This is a customized, specific meeting. And then if anything, I will educate you specifically about your unique situation. And then if everything you would not happen to you as you would want. So if you have concerns, we design a plan to make sure everything is handled as easily as possible for the people that you love. By doing that, you can make informed decisions about whether or not you need to take steps to make life easier for your loved ones, if anything happens. And that's what it's all about, making informed, empowered decisions. So here's the thing that is important for you to know about the family wealth planning session. This is not something you do for you. It's a gift for the people you love most because it's a lot easier for you to take care of these things while you're living than it would be for your loved ones to take care of these things after you're gone. Now, normally a family wealth planning session, a private 2-hour consultation with me is $750. However, because you have downloaded my cheat sheet and watched this video, I'm going to give you 2 gifts. First, I'm going to waive the fee for that family wealth planning session. If you simply click on the button below this video that says schedule my family wealth planning session and fill out the questionnaire there, I will waive that fee. Use the coupon code webinar, and the fee will be waived for you. And the second is that if we decide that you would like to retain me to provide estate planning services for you, I will give you a credit of $250 toward any estate planning services that you retain me for. Now, some of you have already done some planning, certainly. You've come here looking for some information about wills that you have purchased online or that you're considering. And if you already have an estate plan, the planning session is even more critical because, to be honest, it's very likely that the plan that you had prepared was prepared by an attorney who focuses solely on documents, on document preparation, and doesn't ensure that your plan stays up to date in the right way. My father-in-law worked with an attorney like that when I was in when I was in law school, and he spent a few $1,000s on a plan so that he wouldn't have to deal with the probate court, and he wouldn't have to deal with his ex-wife after he died. Now, only after he died did we find out that he had a nice plan and legal documents, but the fact of the matter is the lawyer had not kept those documents up to date or titled his assets properly, which meant we were stuck in court dealing with his ex-wife, exactly what he had paid to avoid. I thought for sure that this lawyer must have committed malpractice. You can imagine my surprise when I later went to work in developing an estate planning practice and found out that was exactly how many attorneys did things. It wasn't malpractice at all. It was common practice. As a personal family lawyer, I have a mission to work very differently. First of all, I focus on planning from a total perspective, taking the needs of parents in mind. More importantly, I don't see legal planning for your family as merely putting in place a set of documents that you sign once, throw in a drawer, and never look at again. As your life changes, your assets change, the law changes, and your plan needs to change with it. We ensure what happens by ensuring that your assets are owned properly, reviewing our plans at least every 3 years, and that we have membership programs so that we can provide ongoing legal guidance to our clients without ever having to pay an hourly fee to talk to your lawyer